Hi, I'm Greg Dell here with attorney Alex Palomara. And Alex, today we're going to talk about MetLife group disability appeals. There are also individual MetLife disability claims as well, and sometimes they offer appeal, but I'd say 95% of the MetLife disability policies are group policies, and if you've been denied, then you have to file an appeal. So this whole video is going to be about our experience in handling these MetLife group disability appeals and then offering some tips for people to understand the important reasons as to why you should really have someone help you file this appeal. And even if you're going to do it on your own, a lot of the important things that you have to have in your appeal. But the first thing that's like super important is, why is it so important to get every single thing into the appeal?
Well, the ERISA laws that govern these group policies, or govern most group policies, are very tough laws. I mean, they pretty much favor the insurance company, and your appeal is your last bite at the apple of strengthening your claim for a potential lawsuit. The purpose of an ERISA appeal is, one, to give you one more chance to get back on claim, to have MetLife reevaluate the information you send them, and to reinstate your claim. But the second purpose is to strengthen your claim for a lawsuit, because once MetLife issues a final denial, you cannot get any more documentation whatsoever into the claim file. The claim file is the information that's going to be in front of the judge. So once the final denial is issued, that claim file is closed and no more information can be submitted to the judge.
Okay, so like you said, it's a final bite and the first bite. And a lot of people call us when they've been denied already on appeal, which is fine, and we help those people, but we're married to what they did already.
Correct.
So let's get right into, where do we go? What's the starting point to determine how we're going to put together a strong appeal for a MetLife denial?
The starting point is the easiest point, and that's literally sending them a letter requesting all the files that they have to provide to you under the ERISA laws. They'll send you the claim file. The claim file can be anywhere from a few hundred pages if the claim is relatively new, to thousands upon thousands of pages if the person's been on claim for 10 plus years.
Okay, you get these thousands of pages or a couple hundred. Usually it's a minimum 500 pages. What's the first piece you're digging in for?
Well, the funny thing about claim files is that when you receive them, there's typically no rhyme or reason how they're organized. So essentially, you might be looking for a needle in a haystack, as they say. You have to find a few documents. And the most important documents, you'll actually see in the denial letter, they'll talk about the reviews that they're relying upon that they believe justifies their denial. So maybe they did a consultant review where they sent your medical records to a quote-unquote independent physician consultant who conducted a review. Maybe they did a couple of those reviews. You have to find those reviews in the claim file, and they might be 6-7 pages long, sometimes as short as 2 or 3 pages. And in those 5 pages in the claim file, the 5,000-page claim file, you have to find that needle in the haystack. Beyond the consultant reviews, they could have done an independent medical examination of you. They could have had you submit to a functional capacity evaluation. You have to find the reports from those examinations. They could have done surveillance. You have to find the surveillance documents in there. Sometimes they'll email you, or not email, they'll send you a CD with a copy of the surveillance on it, but you also want to see the report to see what the person who did the covert surveillance actually thought they saw. A lot of times in the denial letters, they'll describe something, and you'll watch the video, and they were very liberal with their description of what they actually caught on video. So you have to find these documents in the claim file. It's hard to do. It's a needle in the haystack, but those are the first few things you must pull out of the claim file.
Okay, so you get this whole claim file. I find MetLife's claim files are usually intentionally a mess. The stuff's spread all over the place. There's no table of contents or contents or index or anything to go through it. Obviously, we're very skilled at going through it. When we get it, though, is when the real work really begins. And that's when we're going to say, okay, here's why they denied the claim, which is usually an adoption of whatever their outside doctor did, or their nurse or something like that, or they got the treating doctor to say something that's not really consistent with the treating records because they reached out to them. And I think that's when the real work begins that we do, is then taking that next step to reach out to the treating doctors and say, hey, what's your opinion based upon what their treating doctor said? But we don't just send them a letter and say, what do you think about this? It's talk about the custom attending physician statements that we work on in order to help prove our clients' restrictions and limitations and inability to do either their job or any job.
Well, we will reach out to the doctors and hopefully get the doctors on the phone and explain to them the situation. We'll explain to them the definition of disability, what it means to be disabled. We'll send them a copy of the review or the report that MetLife's hired consultant wrote. We'll have the doctor review it. We'll ask him or her whether they agree or disagree with the ultimate findings, whether they see any holes. We'll point out the holes that we find in the file. We'll let them know or let her know what we believe they overlooked or why we believe that this doctor came to the incorrect justification. The next thing we'll do, as you mentioned, is we will draft attending physician statements particular to our clients' claims. Not every claim is the same. We draft attending physician statements for each of our clients just because every single client's medical condition is a little bit different. Everyone could be suffering from fibromyalgia, but there's always different variances for each client. So it's very important to have a specific attending physician statement written for your claim and actually written for your specific doctor. And then the doctor can make recommendations if there's any changes he or she sees fit. And hopefully they'll utilize the form that we drafted for them, and it'll be very supportive of your claim.
The other thing we often do is I find that the medical records are incomplete. And when I say incomplete, doctor had enough to treat the patient, because the doctor treats the patient, not the chart.
Correct.
But very often Met is looking at the chart because that's the only way they evaluate the claim. So by doing that, they're saying, oh, well, we see your subjective complaints, but we don't find enough objective evidence. And so we are forever working with the claimants and the doctors to get additional objective evidence. If somebody had a neck or back problem and is complaining of radiating pain, we would probably push our clients to either get an updated MRI, an updated CT scan, possibly an EMG test, a nerve conduction study test. And then we may even do our own functional capacity evaluation that we'll send them out for to try to show objective evidence of their functional limitations. And so whereas treating doctor is never going to do this, a claimant who doesn't have a representative, so, an attorney like us who knows what the insurance company is looking for would never get this stuff. So basically the insurance company sends the claimant out by themselves and says, go ahead and just send us a reason why you think you're not disabled, which is a trap. And we'll go ahead and reevaluate the claim. And as all they do is send back basically the same medical records or new medical records out to another treating doctor or an in-house doctor and basically just agree again with that doctor. So our job is to present evidence that they can't refute. That no reasonable doctor could say, I disagree with those conclusions of that doctor, and basically gets them to the point where they say there's no way that person could go back to their job or go back to any job if that's what it is. The last piece that we do, we talked about medical, but in every appeal there's a vocational component. Talk about how we work through that vocational/occupational component in an appeal.
Well, one thing about group policies is that typically the definition of disability changes after a certain time period, and typically that time period is 24 months. So for the first 24 months, you have to be unable to perform the duties of your own occupation. And after 24 months, it gets a little bit more complicated. You have to be unable to perform the duties of any gainful occupation or any occupation for which you're qualified based on your training, education, and experience. During the first phase of the own occupation phase, you will see a lot of the times that the insurance companies will take great liberty at interpreting what your own occupation is. They'll look at the dictionary of occupational titles and say, this job seems the most similar to your current job, and more often than not has nothing to do with it. They've ignored the actual job description of the employer. They've ignored what the claimant has told them, and they find some job that is very minimally related to the job they actually did. And they take that definition of disability, the own occupation, and they run with it and say, hey, listen, we reviewed your medical records and we find you have the ability to perform your own occupation. It is important to not only maybe speak with, and we often do this, speak with a vocational expert who will help us explain the job requirements and duties and of our client's own occupation. And furthermore, we can use it for the any occupation stage because that person can tell us if there's any jobs that our client is qualified based on their restrictions and limitations.
And then also talk about the market labor analysis, market labor study for available jobs out there.
So in most any occupation stages, even the own occupation stage, there's a requirement. There's a requirement of it. There's an income component to prove that you can't do any occupation. They can't just have you be the quote-unquote greeter at Walmart, where you have the ability to sit there and wave hello to people. That means you can perform any occupation. The insurance companies like to believe that if you can do a sedentary job in most circumstances, because a lot of people are physically disabled, they say, well, if you can do a sedentary job, if you can sit somewhere for 6 hours a day or 8 hours a day, you're no longer disabled. And they use the old greeter analysis. But most people are more qualified than to basically be unqualified to work as a greeter. So when the insurance company says you can do this sedentary job, they have to have, there's an income component, and they have to be able to show that it's 60% or 80% of your prior monthly earnings.
So with these MetLife appeals, you know, we'll always get into the medical, we'll get into the vocational, we'll get statements from the claimant, we'll get statements from past coworkers, we'll get statements from family members, and we'll really articulate, and the thing is, this is all on paper. So it has to be presented in a very, very strategic manner without telling the disability insurance company what they have to do on appeal. Because if we tell them everything they have to do and they go ahead and do it, then we're not going to have a good leg to stand on in a lawsuit because of the arbitrary and capricious standard. And so we have other videos about what happens if you have to file a lawsuit, which you can definitely watch. But after we have filed well over probably 1,000 appeals against MetLife, we know exactly what they're looking for. We know exactly how to present your claim to put you in the best position to win. So we handle these MetLife claims all over the country. We always offer a free initial consultation. The only thing you got to do is send us a copy of your denial letter. We'll review it right away, and we'll let you know immediately how we can help you.